can you do this committee a favor with your own views for consideration by the Constitutional Review Committee? Can you share just one?
Honorable Chair, I think earlier from a question from a member, I came out with two. That is the appointment of majority of ministers from Parliament, and also a suggestion that the procedure for the removal of the Chief Justice should be applicable to the removal of all Superior Court judges and the regional tribunal. As the procedure stands now, in the case of other Superior Court judges, including the Supreme Court judges, the decision of whether there's a prima facie case is taken by only the Chief Justice. Thank you, Honorable Chair.
Now, let's deal with Parliament. The issue of parliamentary quorum and voting under Article 1041. Currently, we are 276. Yet, in practice, most business is conducted through committees, and during plenary sessions, attendance often fluctuates because members go in and out. Against this background, Article 1041 of the Constitution provides, quote, "Except as otherwise provided in this Constitution, matters in Parliament shall be determined by the vote of the majority of members present and voting, with at least half of all members of Parliament present," end quote. How do you interpret the requirement of 1041, especially in terms of quorum and valid decision-making in the House? What's your own view on this?
I believe that the Constitution is very clear, and the issue of quorum will be determined on the number of parliamentarians, and what the law provides should constitute majority of those present. Thank you, Honorable Chair.
My Lord, have you had the opportunity of reading the Justice Abdullahi case?
Yeah, I have.
Without refreshing your memory, can I proceed to pick your thoughts on that judgment? If you need to refresh your memory, fine, I will stay away from it. But if you are so clear with the judgment, I may want to tease your view on aspect of it.
Honorable Chair.
Honorable members, we need to operate within the rules. This is a judgment delivered by the Supreme Court, properly constituted. Here is a nominee before us, asking him his thought on a judgment delivered by the Supreme Court, which is binding. I do not think we are fair to the witness in the circumstances.
Chairman, you are taking your powers too far. We are here conducting this exercise. We've had nominees expressing views on judgment, expressing views on judicial pronouncement. How then the nominee says he's read that judgment? I'm asking a question within a certain context. I need to pick his views on it. It doesn't mean he's going to condemn the judgment or he's going to question it. Then if you are ruling us out of order this way, then why are we here, Chairman?
Well, take a cue. A question was posed to Justice Sir Dennis.
Oh, Jesus.
And he indicated that once the Supreme Court has delivered a judgment, that is the decision of the judgment.
No, please.
The word he uses, whom am I to comment on that particular decision. That was what the judge said. It's a similar thing that you are.
I think that we need to situate some of these things in proper context. What my Lord Dennis J said was misconstrued by you with the greatest respect. He understood the question to mean that he having to overrule that. And then he said, oh, that is the decision of the court. Who am I? He didn't continue. And I understood that to mean that, yes, when the court has ruled, it is binding. And I went further to say that the recent Kowasefua case, I had my own disagreement. But in the spirit of that principle of yielding in obedience to a court decision, I had to even rely on the majority decision led by my Lord Kulendi to make my case on the floor of the House. I moved away from that to then ask him his view. If judges come before us and they cannot express their view on a matter, we are not saying that they should sit here and overrule. That is not what we're saying. A judgment is binding on you, but you can express a view. And don't forget that the same Dennis J talked about the end-all interpretation, where he believed that a particular panel interpreted the end in a manner. And when that panel was out, a new judge, a new panel led by the all group gave a new ruling, and that was it. So please, I don't want us to be having back and forth on the matter. So I only ask, can I finish, Chairman? Chairman, you would say what you want to say. Please, bear with me, with respect. I am not locking up the nominee's neck in any hole. I ask, my Lord, have you read the Justice Abdullahi case, which is relevant to my question? The article I quoted, he said yes. And I said, my Lord, if you can proceed to answer questions without refreshing your memory. If he says that he would need to refresh his memory, we move. Because if the man has read and he doesn't have the judgment with him here, I cannot ask an opinion. That does not mean that I'm asking him that a judgment which is binding on him, he should come and condemn it. That is not the gravamen of the question. So please, Chairman, well, let's get exercise right.
Honorable Minority Leader, we are all here.
All say congratulations, well done.
Thank you.
I looked through your CV and I realized that you are a basket of a lot of knowledge and good things in your own industry.
Thank you.
We have observed that in our justice system and justice delivery, many a times, a lot of your work is delayed. A lot of your work is delayed. Someone could be in court for even 10 years. Not even only, not in your place, the superior, but even the lower courts. So there is this perception that justice delayed is justice denied. What is your view on that perception? And what will you suggest to be done to stop or at least to reduce the delayance in justice delivery? Thank you.
Thank you, Mr. Chairman. Some few minutes ago, I said we have to look at the tools we use. We have to go high technology now, AI. One of our main constraints is the recording process, writing longhand, and then the processes by themselves. A lot of people who don't know this always say cases delay unnecessarily. Yes, sometimes it does, but then the procedures we have to see to it that we shorten the procedures and the time limits. Then secondly, I talk about the tools. If we can go AI, said that recordings are done swiftly, so that by the end of the day, whatever everybody says in court is recorded by the machine and at the end of the day it's transcribed and you can just sign. It makes it faster. And then number two, a lot of adjournments. That one depends on the courts. A lot of lawyers come, I'm sick, I'm that, sending letters and blah, blah. We have to curtail those things as well to make sure that cases go on. And then I said something earlier that there should be time limits. I think the rules of court should set time limits, that no criminal case should go beyond 3 months. No civil case should go beyond a certain period of time. Then we all know we are constrained to finish within that time. These are the things we have to do to be able to quicken cases, to fasten the delivery of justice. And then more courts. If we have more courts, then the workload is lessened. One court wouldn't have plenty cases if there are other courts around. So, Madam, these are some of the things we have to do to be able to deliver justice in good time. In good time. Thank you.
Chairman.
Any further question?
Yes, please.
Please do.
Something of very big interest. If you go to our prisons, most of them are choked. And it's as a matter of judgments, either delayed or wrong judgments or whatsoever. My main worry about those in these prisons are that some of them are not persons whom we should even send to prison, or we should even delay their cases. Someone goes to steal a bunch of plantain. An underage goes to steal some rice in a cooker and is eating. All these people, you collect them, you go and dump them, and sometimes even they are not segregated. The hardened, the non-hardened, all of them are together. What will you suggest to ensure that I will call these people, these little pilfering and what have you, they don't find themselves languishing, sometimes even years, sometimes forgotten, either in being called that they are in detention or they are whatsoever.
So, Honorable Hajaladi, what is the question?
My question is, what will you suggest to be done to those people so that we don't get them going into detention and wasting time?
Thank you. You said we collect them and go and dump them. We don't do that. We try them, and if they are found guilty, they are convicted and sentenced.
Please, I'm not referring to the convicted ones. I'm referring to those that, for instance, you just say, oh, you have to go and come, every day go and come, and the place is choked. When the police cells are full, you remand. You send them to the prisons where maybe they are not even supposed to go. They are the ones I'm referring to, but not the convicted ones.
Thank you, Madam. We as judges interpret the law, the laws you make. If you change the laws, we interpret it accordingly. The prosecutors come to ask for remand because they have not finished with investigations. Madam, you can't ask the people to go home. You remand. But like you are saying, of course, it must be reasonable time. So until the laws are changed, there's nothing the judges can do, please. Thank you. So we are waiting for you to change the laws. Then, for example, the penal system, we are looking up to you. If you change it, fine. Thank you.
Yes.
I think I'm done.
Very well. I'll proceed to give the floor to the Deputy Ranking, Honorable Patricia Apiaje.
Right, thank you very much, Mr. Chair. I'd like to find out, at what age did you enter the secondary school?
A little less than 12.
Specifically?
I went to the secondary school in 1970.
Yeah. So we presume that you entered at the age of 11.
11 plus some months, please.
Thank you very much. I found it very interesting because at that time, we had people entering secondary school at the age of 13. So I found it very interesting.
Luckily, my father was a head teacher, so I school.
Right, thank you. Honorable nominee, how many judges do we have at the Supreme Court currently, practicing judges, and how many are women? I'm talking about current one. How many are women?
Currently, we have two, Justice Avril and Justice Mensah Bonso. And then the CJ Justice Tokono, 3.
And how many in total, please?
13.
13. Thank you very much. Honorable nominee, I'll proceed to bring to your attention that last year, 2024, exactly in June, the Gender Equality Act, Act 1121, was passed. One of the questions I want to put to you at this point in time is that this act mandates gender parity in public appointments. And Article 144 requires merit-based judicial selection. If these provisions conflict, for example, if achieving gender parity requires appointing a less qualified candidate, which takes constitutional precedence and why? Which of the two? I've given you indication of the constitutional and then the legal aspect of it. Thank you.
Mr. Chairman, as much as possible, you should send the best to the Supreme Court, or you should appoint the best wherever. You don't use the gender equality thing to appoint somebody who you think is not qualified, but because of gender. So I will always go for the quality. If it means one person who is qualified, fine, go for that person. Don't say because of gender. If the person is not suitable or qualified for the job, you appoint the person to satisfy gender equality or gender parity. Thank you.
Thank you very much. So, to follow up, I would like to find out, what would you suggest should be the best approach in ensuring the achievement of the gender parity as it exists in the law? Thank you.
Mr. Chairman, if a lady qualifies, or yes, if a lady qualifies for a position, why not? Gender parity does not necessarily mean that you appoint women to satisfy the numbers. No. If the woman is qualified equally as the man, then when you are appointing, you look at that. You don't give the chances to men as against women. But that does not mean that you push ladies who are not qualified for the job to satisfy that parity. Thank you.
So, Chairman, I think I need clarity on this because I asked a specific question. What would you recommend should be the approach to achieve that? Thank you.
Madam Chairman, if you pass me through and I get to the Supreme Court, then maybe when it comes, I can then recommend, but as at now, I cannot recommend anything. Thank you.
They don't mean. We can't gag the press. So far as they do a good job and they don't misinform or disinform, we don't have any authority to gag them. The only guidelines are make sure what your reportage is the truth. The press can come to report our cases or come to do anything with the judiciary. We are not sacrosanct. They can come and do that. We don't have the power to stop them, but just make sure that what you are reporting or your reportage is the truth and it's fair. And then as much as possible, do follow-ups before you come out. If you don't understand anything, ask. Don't report on perceptions. Please, Mr. Chairman, don't forget the judiciary is different from the judicial service. But a lot of people mix these things up. Things happen in the judicial service are attributed to the judiciary. We are two different arms, but working together. Thank you.
That was not the issue before the court. So my simple understanding is that it is to give legitimacy and to end the cap. So the cap has been fixed, the 3. Because why do you go? So in that sense, you also go to say that in the absence of the Chief Justice, then in the absence of that person, then what is the essence of providing for leadership in your country? That is the essence. Thank you.
Thank you very much.
Thank you.
Any
There's a
follow-up?
That's right. Mr. Speaker, so by your interpretation, what if by necessity, and there is a Latin maxim that says that necessitatis non habet legem. By necessity, we don't have the president in the jurisdiction. Maybe the vice president has been taken ill, and then the speaker obviously had to be out of the jurisdiction. There can't be a vacuum. Somebody necessarily has to step in.
Well, I will allow.
It's just an academic exercise.
I will allow
the
supplementary question subject to the aspect that says the vice president is ill, because the Constitution used the expression absent from the jurisdiction. So, my Lord, you may proceed to answer the question.
Thank you, Mr. Speaker.
Thank you. You know, there have been 2 Supreme Court decisions on what do we mean by absence of the president, vice president, or the speaker. And it is the interpretation that has been given. And to me, that interpretation to me, contrary to purposive interpretation. Because we must look at the purpose for which the law was made. And why do we talk about purposive interpretation? Purposive interpretation means we look at the purpose, and the purpose is determined by time, circumstances, and development. The things that we had 20, 30 years ago, they are not the same as now. So I believe if in future there should be a decision, the time and the circumstances may change the decision that the Supreme Court may render. It is possible. And we are saying that the Constitution is a living organism capable of growth. And the Constitution can grow at any time. The meaning can change depending on time, circumstances, and development. Thank you.
I will then give the floor to Honorable
Last follow-up.
Bafo.
Mr. Chairman, aren't you enjoying the discourse?
You have exhausted your limit. The majority leader wants a follow-up.
Justice Dennis, if you look at the provisions of Article 60, they clearly anticipate, and I do agree with you, that if the president is not there, the vice president is not there, the speaker. If all of them are not there, the vice president and the president are not there for a given period, the assumption is that, let's say if they are not there and will not come back, if they will not come back, then there must be an election in 3 months, and a new president will have to take over. So clearly the Constitution is firm on the people who can occupy the position of president or acting president, and for what duration they can act as president. So what could have necessitated an obiter to the effect that Chief Justice can act as a president? What, on the basis of which provisions did that come up?
Thank you. It was by Professor Kruje in the case of Asare vs. Attorney General, which I personally, even though it is an obiter, I disagree. Because if you are interpreting, you must interpret within the context, and you must be fair. You must be fair to the text, faithfulness. That is cardinal principle in interpretation, faithfulness to the text. Where it has not been stated anywhere, but I do not blame him because he was discussing the position of the law between 1957 and 1960, where in the absence of the Governor General, all the bills were signed into law by the Chief Justice. That was the position then. So he used that one because that regime, the order in council 1957, is different from 1992 Constitution. So at no point in time can you compare the two. So if you look at, he was influenced by that position, but within the context of the Constitution, it cannot be so. Thank you.
Is it desirable in the context of separation of powers to ever place the head of the judiciary as the head of the executive?
No, please, because we had one in 1957 which brought about problems. Whenever there was a bad law, like PDA, deportation order, the Governor General, Lord Listowel, will travel to England, and the Chief Justice will sign to make him unpopular. So it is not advisable to use the Chief Justice as one of the to exercise one of the executive powers. It is not advisable. Thank you.
Because within the context of separation of powers, if the person who is the arbiter becomes the actor, how do we resolve misconduct by that person or wrongful conduct by that person that gets contested in your court?
Thank you. Thank you, Honorable. It could be a bad practice because why do you involve a judge or Chief Justice whose role is resolution of disputes, which is different from the role of the executive? If it extends to Parliament, there's nothing wrong because they are politicians. They were voted for. They put up their campaign, and at the end of the day, they were voted for. So they can act. But where the Chief Justice, you are supposed to be independent, impartial, and you are to go and perform executive function, it will violate every principle of rule of law. Thank you.